Artificial Intelligence, Law and Justice, session 19. This is the second session of the AI and patent. Let us do a quick recap. In the previous session, we started with fundamentals of patent protection criteria. We also went further and discussed about the challenges AI poses in patenting in theory and practice, particularly when it comes to inventorship. We also dwelt in depth on the human-centric nature of the inventorship in AI and in patent law, and then how AI is really challenging some of the cherished and the long-term assumptions regarding patentability, co-inventor, and also some of the fundamental ideas like should human be the sole inventor or only human should be the inventor and all. In this session, we will go further and also look at some of the other issues and controversial solutions, as well as some of the things which come again and again when we discuss about AI and patenting. So to begin with, we should look two robo scientists, Adam and Eve. They made a breakthrough discovery in 2015. Eve made a discovery against the fight against malaria. Now the robo scientists are scientists enabled, they are robots, but enabled by digital system, and of course they used a whole lot of technologies. And Eve, being a robo scientist, made a significant discovery in the fight against malaria. So they were actually designed and built by a team of Ross, Kling, Adam. So Adam is the predecessor to Eve. Full of automated drug design and synthetic biology was the idea. So they used AI for automated drug discovery. Complex mechanical systems were involved. Look, this is not simply AI. This was also a combination of multiple technologies of using robots, AI being a key component, and of course there was also mechanical systems work. So the patent law challenges which arise from their working is they question the patentability of AI, or the challenges which AI always poses to patent law. Drug development is something very time consuming, involving teams and teams of scientists. Often it takes about a decade or more, even 20 years to commercialize a drug straight from the days of conceptualization, in the sense that preliminary testing, screening, assay development, then validation, then applying for a patent, then going for clinical trials, then getting it finally approved, and then putting it to the market. So it normally takes anywhere between 10 to 20 years. And it's cost intensive in the sense that depending upon the complexity, depending upon the disease, and then so many other factors, it could range from 1 to 2.6 billion. But although does it really need so much money, or are they so expensive, is again a contested topic which we will not go into. When it is such a time consuming and then laborious, money consuming, resource intensive process, anything that could reduce the money, resources, time factor will be something that will really speed up innovation process in drug discovery. So drug discovery process, target molecule or cell structure, then you search for substance with digital behavior, then you construct substances, then optimize the results for effectiveness and efficiency. Now effectiveness and efficiency are important because the problem is that to come up with a single drug that is effective and then finally that could be commercialized, thousands and thousands of molecules or thousands of samples have to be analyzed. Many drug candidates may fail at the clinical trial stage, and all the everything else which has been done in the last 10-15 years may not bear fruit because of that. Similarly, many trials which fail, which may not even reach the preclinical stage, might have been developed at a very expensive cost. It's also the fact that many trials or many experiments in drug discovery, they do not proceed beyond a point because there's a valley of death. The valley of death comes when you know that you have something that could be further taken up, further developed, and then put to market. But then you may not get the sufficient money, or it is also possible that the efficacy and efficiency of the drug may not be so fantastic or so great that they should pour more money to develop a new drug out of it. So there are so many factors. It's more a question of hit and miss. It's more a question of trial and error that ultimately ends in a patentable drug. Now, what did these AI scientists, robo scientists did? They used AI to optimize substance selection, or they used AI to do something that is very fundamental, but AI, they did it in such a way. Let us now take a detour to antenna design. Antenna design is a challenging one because achieving a specific radiation character is very difficult. And then designing antenna is difficult even for experts. But AI simplified the design process, and then NASA has been using AI for antenna design for many years. In 2006, a generic programming algorithm created a unique antenna design that resembled a twisted paperclip. So, AI devised a antenna design without human involvement, without human intervention, in the sense that no human told it, no human said you should devise it, you should do that. It devised on its own. So it is an achievement in the sense that antenna design without human intervention was proved to be feasible by NASA when they used AI. Coming back to drugs, what exactly these robo scientists do and who are they? They are located somewhere between human and machine autonomy. They are autonomous, they are robots, they have some sense, they could do multiple things, they could do experiments, they could figure out. Here, the AI systems in case of antenna, they acted more autonomously. And then machines are also capable of finding autonomous solutions for specific tasks. So these are more closer to autonomous invention by humans than drug development. Because drug development requires human oversight significance and more importantly human interaction. It is also a thing that human interaction in terms of further direction, sufficient data, everything need to be done when you interact with robo scientists to develop a drug. But in later years or even the near future, as AI is being used extensively in drug discovery, if not all the AI drug discovery processes and initiatives use robots, increased autonomy, increased capacity of the machines to identify and then work further, and then by their own learning process and other things, and then with more and more data, they can simulate, they can synthesize, they can come up with drug candidates in a much faster, much better way. In the sense that the drug development process could become less human interventionic, more AI system dependent. Of course, AI system on its own is powerless. We need to give input data, we need to train it, we need to give a lot of things to that. But the point is, drug development in that case may become less human intensive. Humans will be involved, but not the way right now it is happening. And then more AI or more AI system oriented in the sense that the developmental stage, the autonomous stage, the stage of further refining, redeveloping, testing and then developing and then also simulating and also to a great extent identifying potential candidates, or in the drug discovery process what humans could do, AI should be or could be able to do with the same efficiency, with the same idea of selecting the right candidate. So if that happens, the drug development process, the way it is being done now, will undergo a paradigm shift. Humans are there, but then humans' role is very limited. So the question here would be substantive aspect of inventorship, will that shift from human to AI or robo systems or combined systems where robo, AI, mechatronics, everything comes together. Again and again, the fundamental problem we are stuck with is natural person as a inventor. DABUS, the same problem happened. Human contribution to AI inventions could be something different because we formulate the task and then we look at acknowledging result, everything. But if we go for a broader interpretation and then say the substantive aspect should be looked into, and then if AI can come closer to the inventorship idea, if AI can really develop a drug based on the data given to it, based on some of the other parameters and guidance, but without much subsequent human intervention, we can substantially say, or to a great extent we could conclude, AI has attained the level of an inventor, or AI is graduated to the level that we can say that AI as an inventor in some disciplines or in some innovations is something that should be recognized, acknowledged, and then should be allowed, which means that we need to relook the human-centric inventorship idea. So when we say, we can look at it in a beautiful graph given by Alfred Fifth. It is there available in the Critical Mind book. So he says that broad interpretation, narrow interpretation depends upon the level of autonomy, and then the human extension, and how much is the one where humans figure, where the missions do. So as it goes more towards more and more mission autonomy, we need to look into the idea of inventorship as a progressive one. The progressive in the sense that missions become more autonomous, they attain the level of human inventor, or they are due to be claimed or at least recognized human inventor. So the inventorship in the age of mission or learning and artificial intelligence, by this chapter gives us very good insights into it, but I cannot go into the each and every detail of this chapter. But the fundamental idea which is given here is something that is very substantial for us to understand. So if we understand, or if we can put the logic in this way, as missions become more autonomous, humans come here. So when humans intervention, inventorship is more, missions is less, the question is doesn't arise. But when the balance is tilted in favor of missions, or we ourselves make the missions more autonomous with inventive capacities, the balance shifts in their favor. So the whole debate naturally has to move to the direction where we recognize them as inventors. But as full inventors or as co-inventors, that's a difficult question. But this world is full of procedures, forms, classifications. Someone has to sign, someone has to type, someone has to certify, someone has to endorse. And patenting is no exception to this. So if you really file a patent form, besides the technical documentation and all, you need to fill up a whole lot of other details, including who is the inventor or inventors, or the other details need to be given. The inventor column cannot be left blank. Even to meet the formal requirement, fundamental requirement, I need to put some name there. I need to identify a person there. So the mission cannot be put as an inventor, and this is the DABUS case. So the mission not being meeting the criteria of an inventor, EPO or European Patent Office said you did not meet the criteria, refused, did not even examine. So very simply, no rights will be granted if you list mission as inventor. Rights can be granted only if a natural person is put there. So the requesting human inventorship in one sense can be argued as outdated, because DABUS is the inventor here, not humans. So the whole idea of mission-centered thing comes in again and again. But problem is that policy adjustment where it should go is a big issue here. How do we overcome the human intervention requirement, if at all we want to overcome it? We don't know. In future we may be so adamant that we will say AI is fantastic, AI has got great things, but we are humans. We cannot afford to give up the idea of inventorship and then say, oh, AI, he can also be given it. We can take such a stand. Nation governments can take such a stand. So proposals for non-human inventorship have been made in the literature, stating that invention to mission may be impractical, but feasible solutions can come, because missions may not, or may have legal status, may not have legal status, and then patents cannot rights to machines. These are all fantastic. But there are some alternative solutions, like companies are original right holders. A limited company is a legal person. Many of the legal persons are not human persons, in the sense that they are not humans. So extend the idea of legal person to AI systems. We can tweak around the notion of them being the inventor or the patent applicant or the right holder. So if companies can file patent in their name and then claim as original right holders, why not AI? And then if companies can claim AI based inventions in their own name, why not extend the logic and then say hello, AI is also to claim the name? So what amendments are required? Where do we begin with amendment? Should it begin with a patent application form, name of the inventor, AI system 10.2.3, blah blah blah? Or should it be something like that should total overhaul of the system is required? We are not clear. Because the problem is, it is not the question in theory, it's also a question in practice. And in practice, the important thing is that the rules have to be consistent in each stage of the patent application, scrutiny, analysis, and then grant. if the rules themselves are not consistent, it will create chaos. For example, if the application form says that you can put AI there as an inventor, but some of the criteria later does not allow AI as an inventor, or the rules are tweaked in such a way that you can still file an inventor AI as in the form, but the final thing AI will not be given. So where do we make the change here becomes very interesting to look at. So there are two options available here. One, we can try to patch up, bring some changes marginally, begin with application form, like AI can be put as a co-inventor or some as a AI can be granted some rights, but then we can say that as the number two as not as number one. But you can say AI can be the co-inventor, but in the patent application everything is done. You should come up with a disclaimer that although AI is granted listed as a co-inventor, AI will not have any rights for the invention, or AI will not claim any right as inventor, or AI is not the one that is going to assign the patent rights to someone else. So some sort of thing can be done. But will that be sufficient? Will that be necessary? We don't know. So this tweaking can happen in some ways that the inventorship criteria can be partially relaxed, as we saw in that moving towards to mission autonomy, moving less towards human autonomy. Then we can arrive at if the patent application and the patent applicant, human or the legal person, can prove that 50% is the inventorship, then if it is proved to the satisfaction, of course, we'll have to evolve a lot of rules to do that. And then that is a pretty complex one, because then each AI system being a black box, how do we define and then decide that is a totally different topic. It is feasible. Like whether it is 20% or 80% or 70% is a new different question. So, moment we concede that AI can also be a co-inventor or a joint inventor, or can be number two or number three in the application, we are slowly moving towards a change, a fundamental change, which thing goes beyond human invention requirement. But if you totally transform everything and then say that irrespective of all that, AI can be an inventor, then there will be chaos, because if we have not set the norms rightly, as we saw, the number of AI related patent applications or IP applications are booming. So the system will have too many applications for either as AI as co-inventor or AI as the primary inventor. And then it will be very difficult to even deal with them. But the whole international IP system revolves around the TRIPS agreement, that is Trade Related Intellectual Property Rights Agreement. This is the fundamental agreement under WTO that sets the norm for all IP rights, including copyright, patent, plant variety production, and also trade secrets. So, TRIPS agreement is the one that's the golden standard, or every nation's patent criteria or every nation's patent act, copyright act, everything has to meet the norms set in TRIPS. Or in other words, if they are found to violate or inconsistent with the norms set in TRIPS, they could be set aside or they could be held as invalid. Now, TRIPS agreement does not look into the moral rights of the inventor or inventor. That is 1.1. Then, inventor is disclosed only in the disclosure requirement. So, one set of argument could be that there is no question of moral right. So, TRIPS per se does not prohibit AI being claimed as a co-inventor, or when it comes that disclosure norms based on Article 29.3, one can be tweaked up. And then TRIPS give full flexibility in some aspects when it comes to invention. In the sense that how do you define an invention is patentability criteria. TRIPS does give you full, not full, some sort of flexibility. And then certain inventions cannot be denied in some countries, but certain inventions can be denied in some countries. For example, some countries it is patent, you can patent a genetically engineered mouse, whereas in some countries you cannot. And then Europe has its own patent convention where the norms of ordinary public morality are there. So the conditions vary, the criteria vary, but the fundamentals remain the same. And more importantly, TRIPS is technology neutral in the sense that it covers all fields of technology, all fields of science. So TRIPS agreement agreement which could be the starting point for such changes in one way to look at it. Countries can agree, insert some sections in TRIPS for copyright norms related to AI based inventions or AI as author. And similarly for patent, they can bring some norms. But again, to what extent those criteria or those articles will give flexibility, and then how to match them with the broader idea of copyright and patent under TRIPS will be something that has to be really discussed and sorted out. Because when we talk of patentability criteria and then what inventions can be patented, if flexibility is given, some countries may or may not allow AI-related inventions to be patented. Some countries may allow. So broader consensus on the fundamental issues is more important than trying to tweak or trying to do some tinkering job with TRIPS and other agreements. Paris Convention relatively is an older one, but then TRIPS is the current norm. So we have mentioned Paris Convention more as to indicate that again it does not define inventor, leaving the individual nations to decide. We have talked about authorship, we have talked about inventorship, we have also talked about autonomous systems, how the autonomy moves. But question here is to the other important aspect in patenting and patent law. Can a autonomous patent system infringe a patent? Can we attribute infringement to AI? And if can attribute infringement to AI, who is liable? Is it the AI or the system developer or the one who developed and then used the system? Who exactly? And then if AI is autonomous, if we can claim that AI is autonomous, it can take a decision, it can claim inventorship. Logically, that should be extended to AI. If you can invent something, you also have the capacity to infringe. So you cannot take an argument, AI can be an inventor, but AI cannot be an infringer. Both are not consistent. Either totally this or totally that. You can say AI cannot be an inventor, following it that AI cannot be an infringer. Similarly, AI can be an infringer and AI can be an inventor. But the problem is AI systems may have multiple parties. In the sense that the developer, then the one who fixed it and then who using it, then someone who made subsequent modification to that. And then same AI system could be used by multiple parties for multiple purposes. And then AI system can be part of a larger system in a corporation or in a larger ecosystem of AI systems interacting with each other. But infringement, one thing is that is there an intention to infringe, or this is something like criminal act in the criminal mind. Is there a criminal mind to infringe? Can we attribute that to AI? And then is there a real intention that AI did that with purposefully and with knowing fully well that infringement is a crime, it is punishable, or did it happen on account of some unanticipated development where nobody could be held responsible? These are some of the fundamental issues that need to be tackled if you say that AI can infringe. Coming to the next point, attribution of AI Act in patent law, whether it autonomous act, it is something which is possible in General Tort Act. But as of now in Patent Act, we do not recognize them as AI agents or autonomous agents. So that is difficult. On the other hand, one argument could be that direct use of a patented invention, AI using AI cannot be the one where we can exonerate the user. User should be equally applicable. But equating AI actions to human actions is always problematic. So the question of responsibility for patent infringement, liability, and then the question is knowledge and reasonable effort. Did AI know or did the AI system know that this act is an infringement? Was it aware? And then did it make reasonable effort to prevent it or not to indulge in it, knowing fully well that this can result in infringement, being a something that is punishable? And did the AI system make sufficient effort to know and acknowledge or even to know that what exactly is an infringement, how we should avoid it, or what to do if it is doubtful that it is going to infringe on something? So is the system inbuilt that it takes care of these norms, or this idea that AI system has got the potential to infringe? So these are some of the questions which, these are not hypothetical. This could arise in future, but these are questions that repeatedly keep again and again when we talk of infringement and then attributing AI action patent law. But let us also look at it, the user liability. Setting a cause for infringement. Alleged infringer must prevent infringement by third parties. Then failure to do that. Insufficient measures. AI and patent use. Equating AI with third parties. These are all evolving ideas. User liability for patent violation and then AI system action is going to be very controversial, but something will happen. Then insufficient precautions can itself be something that could be challenged, or that could be forced as an offense, or that could be saying that since you didn't take sufficient precaution to prevent AI infringement by AI, you are liable, and you did contribute to the infringement. So those arguments can be put as you have breached a legal obligation. So linking up attribution and the mental state, and then knowingly infringing or unknowingly infringing, taking steps to prevent infringement, knowing fully well that's a potential. These are certain things which are very interesting, but again, there are a lot of counter arguments for each point in them. Between protection and responsibleness, injured party needs a protection. Responsibleness for obligation to examine and act. But if we extend this logic to AI systems, then it becomes all the more problematic, because as we said, if the user is not held liable or users is exonerated and everything shift to AI system, then how do we arrive at a amicable solution? AI will not be able to pay damages. AI will not pay compensation. Someone has to bear responsibility. But it could be that user will be fully responsible, although the AI is the one who primarily caused it. Or there could be some way out to say that certain things which were caused without any actual intention, or which are caused on account of certain other problem, but not on account of defects, that could be something, a liability that will not be a harsh infringement liability, but something that is less severe. So the questions here is that AI is asking repeatedly fundamental questions, whether copyright or patent law. Then as the systems move towards autonomy, thinking, recreating, full creativity, capacity to develop drugs, capacity to develop molecules, new molecules, capacity to develop so many things, the whole idea of inventing or innovation is also moving towards machines. In the sense that we are still with it, we can work with them. We are not saying that AI will become the sole only class of inventor. We are not saying it. We are saying it as they become more powerful, we are also moving towards working with them, not working against them. So when that machine AI system collaboration happens, the questions again need to be rethought in that context. And it is all the more interesting and important when AI developed drug discovery, or when AI focused identification of molecules in chemistry, or AI developed equations in mathematics, in any branch of science, in any branch of technology. Today AI can come up with new ideas, novel molecules, novel proteins, novel synthesized proteins, or any number of chemical compounds without human intervention, since that humans not be each and every stage. So extending the logic across disciplines, across all the fields of science and engineering and technology, will also mean, since we have been telling that patent is not a technology neutral, is a technology neutral one, is not a technology oriented, and since bias against that technology, lot of things will become problematic, in the sense that AI comes up with a new drug molecule. Of course, the company which invested in the AI will be the one who will be patenting. But it is also possible that the person who developed an AI system with inventive capacity and then said, I am giving it to you on lease, or we both enter into agreement that my system is oriented towards drug discovery, invention, and it has got capacity to come up with new molecules which could be tested, which could be proved. But in drug discovery, the patenting starts at the very, very early stage. You don't wait till you file for the patent or even you prove the efficacy. You file the patent the moment you know that it is going to meet the three criteria. It could be industrially applicable, it is novel, all the things. If you can meet the three criteria, first thing patent companies, pharma companies will do is to go for patenting. So in such a context, if I develop a drug discovery oriented AI system, whether it is an LLM or a call that as a pharma LLM, and then I come up with an agreement that my system will be the one that will be used, and then in such a case, AI, my system will be the co-inventor, and then legally I take responsibility for the actions done by the system. Is it possible to think of such a scenario? Maybe possible in the future. In which case, you can attribute certain things to machines with liability, certain things taken by humans, or with full liability and then full attribution coming with humans with AI playing no role. So how this mix and match of human creativity and AI creativity will work in future is yet to be seen. So what we are saying is that as technology advances, more questions will arise in terms of infringement, liability, inventorship, and more fundamentally the criteria for patentability. So broader agreement at a global stage, at least on the fundamental things, is necessary, but it is not going to happen, or it is not happening because no country is doing any negotiation on AI related patent law amendments, the TRIPS Council, in the sense that certain things are being discussed. Certain things are being discussed in meetings in WIPO and elsewhere, but they have not reached to the stage that countries have proposed that we will have formal negotiations, or we will come up at least as country level position papers for TRIPS Council to take them further. It will come, if not today, maybe in another 5-10 years. So unless there is a fundamental issues and resolving them is done, arriving at a broader is necessary. But irrespective of that, national patent offices, national governments will try to resolve them on their own. This need not wait for the TRIPS agreement to be amended. National governments, national copyright offices, national patent offices can on their own will do many things. But will that be compatible to each other? Will that be TRIPS compatible in the sense that if TRIPS is later amended, we won't know. But we have looked at both copyright and patent, and then also looked at why AI remains as a controversial technology that strikes at some of the fundamental conceptions of ours when it comes to copyright and patent. Also tells us one thing, that AI's role in law and justice is much more broader, much more visible, and going to be much more impactful than we can even think of. So some of these things which we have discussed so far are also tell us one thing, that AI is not yet another technology that has come midst of other emerging technologies. So more challenging things, more interesting things we will discuss in the subsequent classes. As the next class is on AI ethics, we will touch upon what is AI ethics, why there is a need for AI ethics, because we do not talk of AI ethics in the context of many technologies. We do not talk of motor vehicle ethics. We do not take of water pump ethics. We do not talk of electric motor ethics. But why AI? So we will discuss that in the next class.